Today, I want a case based on a video that I never saw, that my client never saw, that the prosecutor never saw, that the judge never saw, and the alleged victim never saw. So how did I do that? A little something called the business records exception to the hearsay rule. In this case, my client was at a factory and he was walking and there was some water on the floor. He slips. In order to avoid falling into a metal table, he grabs onto the upper back of a female coworker. She totally flips out, goes to HR, says that he grabbed me and I didn't like it. I want him disciplined, yada, 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 yada. HR reviews the camera footage and determines that it happened exactly like the way my client said it happened. He slipped, he fell in order to avoid falling, grabbed onto another person, right? Fast forward, the defendant is pulled over on a warrant because apparently filing an HR complaint wasn't enough. After that was deemed unfounded, the alleged victim went to the police and the prosecution and said, hey, I want a police report about this and I want him charged with harassment. And they did that. In Arkansas, harassment is basically any unwanted touching for the purpose of annoying another person. It's a Class A misdemeanor that can carry up to a year in jail, right? The problem with that is when you get a warrant out for somebody, it takes a while, right? It takes at least 30 days, right? You got to go to the prosecutor. You have to swear to an affidavit. The prosecutor takes that affidavit and request for a warrant to a judge. That sits on the judge's desk for a while. The judge reviews it, signs it, sends it to the sheriff. Then the sheriff does whatever the sheriff does, probably just waits until anybody interacts with this person with a warrant and then goes and arrests them at that point, right? They don't even go, for a misdemeanor in particular, they wouldn't go and find you at your house or go to your place of business. They would just put it in the system, and the next time you're driving down the road, they'd zap your license plate or pull you over for something else and say, oh, this guy's got a warrant, let's arrest him on it, right? So how was I able to get this video that no one ever saw into evidence? Well, by the time that this happened, the video had been deleted automatically by the business after 30 days. There's only so much digital space out there in the world. So what had happened is HR sat down and watched this video and wrote down what happened. And they wrote down exactly what they saw, and that was Jose's version of the story, is that he slipped in water and then grabbed onto the upper back of another person in order to not injure himself, right? And because this was in an HR report, it falls under the business records exception. Under the business records exception to hearsay, you got to prove that there's a record, that it pertains to the acts or events in the case. It was made at or near the time the event occurred. It was created by a person with knowledge. It was kept in the regular course of business. The business has a regular, normal practice of recording such information. And its admissibility is supported by the testimony of the person who is the custodian of the records. In Arkansas, there's like an invisible eighth, factor, and that's the general trustworthiness of this document. Now, somebody could argue that it's in the best interest of a company for there to be no sexual harassment to be found from an incident, because that means, well, if there's no sexual harassment, that means they're not liable for any sexual harassment that happened. And so there's kind of like that cloud over it, potentially. Right? But that's only one of the 8 factors. And so we were able to convince the prosecution that, look, this is the only evidence we have. This is the best evidence of what was in that video. And you should drop the charges. And they did. That's it.